Freezing assets during an Illinois divorce. When going through a divorce in Illinois, one significant concern is protecting your financial interests, especially regarding the freezing of assets. Ensuring that marital assets aren't dissipated or hidden is crucial to a fair division. This process, known as freezing assets, can be a powerful tool during divorce proceedings. Legalities of freezing assets in an Illinois divorce. In Illinois, either spouse can request the court to freeze assets to prevent the other party from selling, transferring, or hiding property. This is typically done by filing a motion for a temporary restraining order. The court may grant this order if it believes there is a risk of one spouse dissipating or concealing assets before the divorce is finalized. An Illinois divorce lawyer can help you file this motion and gather the necessary evidence to support your claim. The law firm representing you will need to demonstrate that the asset freeze is essential to protect your financial interests. The court takes these matters seriously and will weigh the evidence before issuing a restraining order. How to freeze assets during an Illinois divorce. To freeze assets during a divorce in Illinois, follow these steps. Consult an attorney. Seek guidance from an experienced Illinois divorce attorney who can assess your situation and advise you on the best course of action. The attorney will help you determine if freezing assets is necessary in your case. File a motion. Your lawyer will prepare and file a motion for a temporary restraining order with the court. This motion must clearly outline the reasons for requesting the freeze, such as the risk of asset dissipation. Present evidence. In court, your attorney will present evidence to support your motion. This could include financial records, testimony, or other documentation showing the potential risk to the assets in question. Court decision. The judge will review the evidence and determine whether to grant the temporary restraining order. If granted, the order will legally prevent either spouse from taking any actions that could affect the frozen assets. Freezing assets is not automatic and requires solid legal reasoning and evidence. A skilled lawyer will ensure that your motion is well-founded and presented effectively to the court. The process of freezing assets in Illinois divorce cases. Freezing assets involves legally restricting access to certain financial resources or property during the divorce process. This measure is typically used to maintain the status quo and ensure that assets are preserved for equitable distribution. Initiating the freeze. The process begins with a legal filing, usually by the spouse who is concerned about potential financial misconduct. The motion must be detailed and demonstrate a clear risk to the assets. Court evaluation. The court evaluates the motion and the evidence presented. This step is critical, as the judge needs to be convinced that the freeze is necessary to protect the marital estate. Implementation. If the court grants the motion, an order is issued, and specific assets are frozen. This means they cannot be sold, transferred, or otherwise altered until the divorce is finalized or the court lifts the freeze. Enforcement and compliance. Both parties must comply with the court's order. Violating a freeze can lead to legal consequences, including contempt of court charges. Your attorney will monitor the situation to ensure that all parties adhere to the court's directives. Freezing assets can be complex, but with the right legal support, it's a critical step in protecting your financial future during a divorce. If you're going through a divorce in Illinois and need assistance with freezing assets, contact the law office of Russell D. Knight today. Our experienced attorneys are ready to help you navigate the complexities of divorce law and protect your rights. Call us at 773-334-6311 to schedule a consultation and visit our office at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States.